So employer liability is obviously very important in terms of discussing sexual harassment. And there are ways for employers to avoid liability for sexual harassment claims. The employer should determine the truth of the allegations. Many managers may have difficulty with addressing sexual harassment complaints. How do you get around that? By training. Have a policy, train the employees on the policy, follow through with the policy. Have an investigation, but the investigation should provide to the employer a basis on which to decide and how to respond. You must notify the complainant of certain items, but don't neglect the rights of the person charged with the harassment, who should also be notified of the claim. If sexual harassment is detected, the employer has to take immediate and appropriate corrective action to remedy the sexual harassment. The most appropriate remedy is, of course, going to depend upon the facts. Invariably, what employers do is try to separate the individuals as much as possible. And if that involves moving them to a different area of authority, you must do so without negatively affecting the victim. The remedy should stop the harassment, but should not punish the victim, meaning I'm going to transfer the parties away and I'm going to transfer the victim to another office, even though he or she may not want to work at that office. So your remedy should be enough to stop the harassment and to not punish the victim. Victims of sexual harassment can also seek other civil remedies that you should be aware of. Tort law provides for remedies for certain acts of sexual harassment. Remember, tort law is this other aspect of the law that kind of acts in conjunction with employment law. You may have a claim that is actionable under employment law or under tort law. So a number of torts can occur in the case of sexual harassment. Things like assault. A tort assault involves not actual assault in the sense that we understand it, but tort assault means that I am being put in the position of anticipating an offensive touching, that I feel as if I'm going to be touched in an offended manner. It doesn't have to be actual physical violence. If it was at a company Christmas party and someone's walking around with mistletoe and they hold it over the head of an employee and say, "Give me a kiss," that's enough for civil assault, tort assault to have occurred. It's just the anticipation, the reasonable belief that an offensive touching is about to occur. Battery is the offensive touching. And again, battery doesn't have to mean physical violence. It can simply be a touching. An offensive touching is enough to rise to the level of battery. If I knock the keys out of your hands, that's enough to rise to the level of tort battery. Intentional infliction of emotional distress, that's a tort. If I cause you severe emotional distress, that's actionable. Not under simply sexual harassment law, but under tort law. False imprisonment. False imprisonment doesn't mean I lock somebody in a prison or keep them in a bunker. Instead, false imprisonment could simply be standing at a door and not allowing someone to leave. That's false imprisonment, and that's a tort, and that could all easily occur in a case of sexual harassment. Even there's no physical restraint. If it appears that I would exercise my physical authority to stop you from leaving, that's enough to rise to the level of false imprisonment. Tortious interference with contract. If you sexually harass someone, you are negatively affecting their employment agreement. And if you interfere with someone else's contract, that's enough to rise to the level of tortious interference. And again, an employer may have indirect liability under a tort theory. They may be vicarious liability. But we said vicarious liability is hard to prove, right? Because you have to show that it was in the course and scope of work. Maybe. But there's also direct liability, which is to say you, the employer, knew this was going to occur and you didn't do anything about it. Or you should have known that this was going to occur, but you didn't do anything about it. That's a claim, that's a tort claim that's separate from the sexual harassment claim, and it's just as valid. Negligent hiring. You hired somebody, you should have known that they could sexually harass people. You know, they did it before, they did it their last job. You could have discovered that, but you didn't do it. That's direct liability. Negligent retention. You should have fired this person the last time they harassed someone, but you chose to give them a second chance. That's a direct theory of liability under tort, negligent retention. You held on to someone when you should have known that you should have let them go. So that's another civil remedy that's available for cases that involve sexual harassment. It's a legal remedy outside the scope of employment law. Harassment could even be the basis for criminal prosecution. Things like criminal assault. Those are clearly are criminal matters, and we've seen a number of cases of people that have gone to jail for what was termed sexual harassment. Well, it wasn't really sexual harassment in the employment law sense. It was a crime. It was an assault or false imprisonment. So in conclusion, what do we learn? The law recognizes these two forms of sexual harassment, quid pro quo and hostile work environment. Sometimes an employer has liability for sexual harassment. Make sure you focus on those two ways of proving employer liability. And then there are these other considerations in regard to sexual harassment claims, primarily preventing sexual harassment from occurring and having a procedure in place in case it does. And that's it. Thanks for listening.